there are potentially two sources that could create problems. One, the creditor or creditors who hold debt that's secured by the house, and the other, the trustee assigned to the case. Now, when I say the trustee, generally in a Chapter 11, there isn't a trustee unless things have gone rather badly. And in Chapter 13, trustees are really not in the business of liquidating assets. So this comes up primarily in Chapter 7. So let's first hit what can be a problem with the trustee. Then we'll talk about how we deal with the creditors. So with the Chapter 7 trustee, the trustee is interested in grabbing assets and liquidating them. So it helps to put this in sort of a conceptual framework. Prior to filing your bankruptcy case, you have assets, the things you owe, and you have debts, the money you owe. When you file that bankruptcy, the act of filing the bankruptcy petition creates a bankruptcy estate. And what goes into that estate is everything you own or have an interest in on that day. And those debts become claims against the estate. Now, since you in the question posed this in the form of, will I lose my house? I'm assuming this is not a business bankruptcy, but a personal bankruptcy. In a personal bankruptcy, we can take stuff out of the bankruptcy estate. And we do that by exempting the assets. What does that mean? Well, in the Chapter 7, we're wiping out debts in one fell swoop. The creditors come up pretty short. And so there are some limitations because that's a pretty extreme relief from their perspective. One of them is on what you get to keep. In other words, what you get to take out of the bankruptcy estate. So one of the things we include in the petition is a complete listing of everything you own or have an interest in, and all of those assets get divided into two categories: exempt, non-exempt. The exempt stuff, that's yours to keep. The non-exempt stuff is fair game for the Chapter 7 trustee appointed to the case to seize and liquidate for the benefit of creditors. In California, we have opted out of the federal exemption table. That's a table that appears in the Bankruptcy Code, but the Bankruptcy Code permits states, if they want to opt out. In California, we have two state exemption tables. One for homeowners with equity, the other for everybody else. What I colloquially refer to as the renter's table, although I do use the renter's table. Okay, so one of the categories in that homeowner's exemption table, because there's a whole list of categories of possessions, is the equity that you have in your principal residence. If you have equity that is lower than the maximum equity exemption, then the trustee is going to abandon all claims against the house. And by the way, a little vocabulary here. Equity is defined as the fair market value of the property minus the encumbrances against the title, such things as mortgages, tax liens, whatever. And so as long as you can exempt all of the equity, then the trustee can't grab it. But if there's non-exempt equity, then the trustee can seize the house and sell it. The trustee, after selling the property, will write you a check for your exemption amount, because that you get regardless of whether the trustee sells it or not. Either you get it as something that protects the equity, or you get it as a check after sale. And then you have to reinvest that within 6 months in a new domicile. So if your equity is too much, in a way that can be made precise based on what the exemption dollar amounts are, then you will lose the house to the depredations of the Chapter 7 trustee. Now, there is a wrinkle that comes up, and that is, although I said that California has opted out of the federal bankruptcy exemption table, there is an umbilical cord that connects us back to that table, and that is, if you have not owned the property, or if you didn't acquire the property more than 1,215 days prior to the day you file your bankruptcy petition, then you have to revert to the federal exemption. And 1,215 days is 3 years and 4 30-day months. So sometimes timing is very important here. If that happens and you have a lot of equity, then you may lose the property because you have too much equity, unless you have the luxury of waiting until that 1,215 days has passed before filing the bankruptcy petition. Otherwise, you use the California exemption, which is really quite generous. Now, there's one other way that a trustee will sometimes grab a house, and that has to do with a concept called fraudulent transfer. And this is a concept that's been around since ancient Rome, so this is a very well-developed area of law. You will not win if you've engaged in this sort of thing. Here's the kind of scenario that can happen. Parent has a house, transfers title to an offspring so that there won't be problems when the parent dies. There won't be some messy probate matter that has to be resolved. Then later, the parent decides to file a bankruptcy case. And let's say the parent is even still living in the house. So the parent is thinking, this is still my house. Well, because you transferred title to your offspring, it's not your house anymore. And if you didn't get a reasonably equivalent value in exchange for the transfer, or the trustee can prove that you did it with the intent to hinder, delay, or defraud your creditors, then the trustee can undo the transfer and seize the asset. And the worst part of it is, since it's not your house, you can't even exempt it, even if you're still living there. So we generally discourage people from engaging in transfers of significant assets in anticipation of bankruptcy. And if you have done such a transfer, either we get you to undo the transfer or, well, look for a new place to live. Okay, well, that's really dealing with the, oh, and there is one final caveat on that. And that is, if you transfer the house back to you, you've only just acquired it again. So you'd still have to wait that 1,215 days if you needed to have the larger exemption. Okay, so that's the first half of the answer to the question. Remember, the question is, will I lose my house in bankruptcy? So there are two possibilities dealing with the Chapter 7 trustee. Either you have too much equity to exempt, or there's been a fraudulent transfer. What about the creditors? I said that whoever holds the note or notes against the property is a potential source of problems. Well, if you're current on the mortgage, that creditor has no claim other than just keep sending me the monthly payments each month. That's it. But let's say you've fallen behind. And just to choose a number out of thin air, let's say you're $50,000 behind on your mortgage payments. Well, if you were to do a Chapter 7, that Chapter 7 is not going to take care of that problem. It's not going to give you a way to catch up on that mortgage arrearage unless the creditor is willing to work with you. And that's a pretty large arrearage. Chances are that creditor is not really interested in working with you and is much more interested in foreclosing on the property. So in Chapter 7, you'll probably lose the property if you have a large arrearage. What the Chapter 7 will do is temporarily give you some relief because all actions by creditors are stayed while you're in that Chapter 7 because of something called the automatic stay, unless the creditor gets that lifted. On the other hand, if you have this arrearage, but let's say you've had a change of circumstances. You weren't able to make the payments, but you now have a high-paying job and you can catch up, but you need some time. Well, in that situation, we can put you into a Chapter 13, which involves a debt repayment plan, and take that arrearage and stick it into the plan and spread the paying off of that arrearage over a 5-year period. Or if your debts are too large to qualify for Chapter 13 in a way that can be made precise, then we stick you into Chapter 11. Same idea. You're going to come up with a plan of reorganization that will cure that arrearage over time. So that means, of course, that not only are you going to cure the arrearage through the plan, but you're going to have to make every mortgage payment that comes due after the day you file the bankruptcy petition. You have to make those payments on time. So whenever somebody says, I've fallen behind, there's a foreclosure, I'd like to save my house, my first question is, what's changed? If you haven't been able to make the payments thus far, bankruptcy is not going to give you a new source of income. What's changed that makes it possible for you now every month to make the payments on time as you march into the future, and be able to cure that arrearage through a plan of reorganization, whether under Chapter 13 or Chapter 11. And if there isn't a good answer to that, then I feel that my job shifts into reality coach mode. That, well, the bankruptcy will give you a little more time in the house, but you're probably going to lose it. So, long-winded answer, but I thought it important to kind of give a full picture of what's going on rather than to utter just a few cheap slogans.